Aaron, I can give my slide to Mr. Neale if that solves that problem.
I'll take it.
Well, I know you'll take it, but if it solves the problem, okay?
How is that, Mr. Odou?
Yeah, I can look at it. Yeah, Mr.
Absolutely.
Neale will be here.
Okay.
I didn't say I'd give it to you.
Oh my God. You're baiting me on that one. Hook, line, and sinker.
Yeah,
You
there
got
you
me.
go.
Sorry about that, Your Honor. We didn't know you'd come back.
No, that's all right. All right, we're on the record, and I just want to, this one little housekeeping, well, I guess we have two housekeeping issues. And I received a letter from badge number 3638, and that's Macedo, and apparently he can't attend the trial because starting on September 10th, September 2nd, September 10th, September 14th, September 17th. And these are actually days, I guess. I'm actually not even reading this right. First entry is from September 2nd through September 5th. He will be in Japan. From the 10th to the 13th, he'll be back to Japan, and so on. And what he is, he's an airline pilot for Hawaiian Airlines. So he'll be flying from the continental United States from September 2nd through September 24th, 5 times.
What's his badge number?
His badge number is 3638.
Hanna has no problem in excusing.
And he says, and this is not the letter from him, this is from the senior administrator for flight operations for Hawaiian Airlines.
Concur. We're with Hanna. There's no objection from
Rule orders.
Okay, I'll let him go, but I just want to let everyone know this. And apparently it's really important for them because they have, they're having problems as far as staffing is concerned, and they don't have enough airline pilots.
Those are speaking Japanese.
We have no objection now.
Okay, we'll release them. You can give this to Lynn when we go back, or you can run in real quick and let her know that we've released them. She might be listening now.
Second item, you had two items of housekeeping.
Oh yeah, thank you. And the second item is this. What do we do from a space perspective? Because apparently all sorts of exhibits and depot transcripts and all sorts of things have been deposited. And I think part of them are exhibits. And my point is this, we've already built up one room with exhibits, and it's my understanding that Tori can address this a little bit better. As far as exhibits are concerned, we don't have enough room anymore, do we?
Correct.
Right? And so we're going to have to utilize the anteroom for that purpose.
Good question, Your Honor. I'll let you know that I believe that all of the parties, as of today, and Mark can make sure that I understand that, have produced all of them in electronic form.
Right.
The hard copy form, which the court has already asked for, we thought, and help me out unless I'm wrong, we didn't want to bring those down when we were doing the jury selection because that's that much more room that 66 people are going to take in all of these chairs. Now, once the jury is selected, having them in other places within this courtroom might be able to be feasible.
Maybe, no question. I think that's a really good idea.
So if you can allow us to bring the hard copies in
Later.
that would be helpful.
Well, what we can do then, and I'm glad you brought that up, I don't know exactly what's been delivered to date, but what we can do then is stop the deliveries, and then after juries, I guess unless you want to use it, maybe we can store them temporarily in the anteroom and then put them in here, something like that. I don't know. How much are they? Corey, you're better than I am.
We currently have 14 boxes. Holds 3. My little vault. So once they are marked as admitted, I mean, there's obviously the exhibit vault, but I have a little room right here that's much smaller. Once the first sticker is on there, they're admitted. They have to be locked up.
Understood.
So the anteroom is ideal for holding that many boxes. It's the only place that where you can put them. My desk right now is buried.
So I'm just thinking the plaintiffs are gonna have a lot, the answer room works great, but I think if we're gonna do that, if we could take the table out of the answer room, it would probably
Yeah.
even be better. And we can move it to any place else, and if you need us to do the labor, we'll do that, but that might work.
We'll have courthouse staff that's gonna be able to do everything that needs to
But
be
yeah, that
done.
works if we do that.
I need it's my understanding that the exhibits that were definitely going to be admitted are the only things being submitted in hard copy form.
I'm not aware that we have agreed on any joint exhibits. Are you, Joel or Will? I'm not aware that we've actually said that.
That was discussed last week.
I'm not saying it wasn't discussed. We need to have that meeting,
We'll do that tomorrow.
so it's still coming up.
And you can check with your staff what they've dropped off.
Okay, we'll do that.
So, who have you received the exhibits from?
I believe it was your office, but again, we've been in here.
Well, I just know they had a couple of dollies out there bringing in exhibits. So.
Those were Kemp Jones boxes that came today, Your Honor.
I have received all of the hard copy deposition transcripts, which need to be in hard copy form, but
We only need one set though, right? That was one thing we were trying to do, is make sure that we multiple sets from everyone, just so we had a sealed copy, right? Didn't we agree on that?
I thought we did.
I thought we
Where are the
did.
boxes from, Lynn?
Kemp Jones had the original deposition transcripts delivered, and Wood Smith had four boxes delivered. That's all we got today.
Okay, so those are exhibits that were on top of it.
Do you want us to pay for a portion of those originals? We're happy to do that.
Yes, we could work that out. With the exhibits, this was, my office's intention was, we submitted all of the exhibits electronically. And there's a lot of them. Most of them are not gonna be admitted or offered to be admitted. They're on the list as just in case for May use. The ones that we know we intend to offer and admit or are likely to, we were gonna print out only those exhibits and bring them down just because they're easier to work with paper and to have them. And so we're not filling the entire courtroom with boxes of paper documents. Is that acceptable procedure?
Sorry?
are you saying that, so.
I mean, I don't store the exhibits. The staff does that.
I just don't wanna have duplications. So if all of your exhibits are electronic, and some of them are hard copy, it has to be all the electronic. I can't do the duplicate thing, cause some would be marked, some wouldn't, and they would have to, it's just a weird process that I have to deal with. So if you're saying that all of your exhibits are on electronic form, but then only some of those are printed, I can't have duplicates. The hard copy would not be marked. It would only be the electronic.
I mean, and ultimately you have to consider during deliberations, what's the jury gonna rely upon?
Hard copy.
I think we talked about that.
We did.
Would it be possible to have the exhibits available electronically and to only mark hard copies?
I believe so. But then
Or generate, I'm sorry.
I got the email about which markings everyone would have. There's up to 10,000 exhibits, so would I just have all of those in boxes or in binders forms?
We would print them out if they were to be admitted, so only hard copies were admitted.
I have to have the exhibits before trial starts. I can't just once the exhibit gets admitted, hand it to me. I have to have it before.
Understood. Can that wait during jury selection because of the, Tori, I'm just asking. What do you think?
We can. I mean, as long as, I mean, jury selection trial hasn't started officially.
I agree with you, but yes, Your Honor, we will do whatever the court tells us to do.
I want to do what's convenient. I don't know whatever's convenient for you, but it sounds to me, I remember we didn't necessarily go into great detail in the past on this issue, but I thought there was a consensus that it would be probably be better for the jury to have hard copies. But 10,000, I mean, I don't, how many boxes do we have now?
We currently have 4. I have to, just exhibits, I have to be able to go through the exhibits before we get into trial.
Could we do it electronically and then generate a hard copy at the close of trial for deliberations?
That's
Of
something
admitted.
I have to ask my supervisors for.
That might make sense to consider.
Yeah, it's just a logistics thing because, I mean, I think the number of exhibits alone, hard copies is just not gonna be feasible. But it is easier, you know, to have hard copies to look at, to go back to the jury. I understand that.
How
So-
about this? I mean, there's a lot of ways you can, handle this. Maybe it makes more sense as far as through the course and scope of the trial to rely primarily on, as far as admissions of exhibits, on electronic copies. Then at the close of the case, as far as deliberations is concerned, make sure the jury has the agreed upon admitted copies for deliberation purposes they can take with them with the laptop or whatever they use.
Yeah, electronic exhibits get presented to the jury on a laptop provided by counsel, a blank laptop, and then they can go through them and they only see the admitted. If you're wanting to admit the exhibits and we're doing it all electronically and then at the last minute we're gonna go and do hard copy, I would have to go through and stick all of them, which would be enormously time consuming. So I need to speak to my supervisors on that issue.
And see,
Certainly, it's not
there-
our
there's-
intent to burden,
Yeah, well, there's
create
another.
an unnecessary burden.
There's another way to look at that, and I guess it comes down to this, as far as the official court record, it has to be what it is. I'm not in charge of that from an administrative perspective, the clerk's office takes care of that. But when it comes to the convenience of the jury, I would think that if you stipulate that if you want the jury to have a hard copy, and everyone agrees, that can't be an appealable issue. The issue comes down to, as far as a hard copy is concerned, is how it will be identified.
Yes, if they're gonna be submitted to the jury through electronic, then it has to all be electronic. If it's gonna be submitted to the jury through hard copy, then you can give me one set of all hard copy.
So Your Honor, I just got a text from Mr. Pepperman's colleague, Hanna. She indicated that 9 boxes of sealed original transcripts were sent from the office and delivered today. She also indicated that they have holo printing 4 sets of everything from our pre-trial being done right now. So that may provide you with a hard copy.
Well, I don't think that Holo is printing all the exhibits. We were gonna print the ones that we expected to admit and use, just so we're cutting down on the documents, but it sounds like that is not gonna work.
For whatever
Yes.
gets submitted, everything for my copies has to either be electronic or hard copy. But if you wanted to do hard copy, then you could just submit the one set of hard copy as the clerk's copy, what will be admitted, and then you can do everything else electronically. But if you're not wanting the jury to have electronic, then it all has to be.
Okay, why don't we,
You
add
talked
it to the
about it.
list to talk about tomorrow and,
And I have a meeting with the supervisor in the morning, so I can discuss this with them.
What time is our meeting tomorrow? Reminder? 11. So we have a meeting tomorrow about 2.67 to go over this. We'll add
That's
this.
at 8.
Sorry. We'll figure it out. We'll get done.
All right. So I guess, what time is it now? It's 4:00. We have enough time to maybe wind this one up.
Oh, we should, Your Honor. I've already said my part on this as far as the opposition that we filed. I was concerned, and I've said this, and I think Mr. Parker said, no, that's not what you filed, and that's okay. What I was worried about, what my concern was, is that we couldn't call any of the treating physicians, including Dr. Dijon as a treating physician to say, did you see this man on this date? When he came in, did he look like this guy right here that's in the courtroom? Or on this picture that we have from his deposition? Is this the guy that you looked at? Is this the person that you saw? Did you talk to him? It was just facts. That's what I was worried about, okay? And did you prescribe medicine based on what you examined him on? Yes. Okay. What happened once he got the medicine? Well, this is what happened to him. Okay. Is this your medical records? Yes. Did you author this? Yes. It's just a fax. That's all it was. And I was worried that what we were going to have, an order from Mr. Parker coming out and says, nope, you can't call treating physicians because all of them are related to causation. I was like, oh, I think that's a stretch. I think that's moving a bit too far. And then you set me straight. And I did not want to put words in your mouth. I apologize to the court. That was not the intent. I got the message. These are fact witnesses that are treating physicians, and they will be allowed under those conditions to be able to testify at trial. And that's all I had to say.
Okay. So, is that the only opposition? I don't remember.
Well, we filed one, but I covered the points about the causation opinions in my prior argument, so.
I understand that. Thank you. Mr. Parker.
Your Honor, I think we've covered it. I don't want to belabor the argument. I think the court's very familiar with Hallmark, very familiar with Williams, and based upon the case law in 16.1, this type of medical causation opinions offered by a treating physician without being designated or without going into a real degree of medical probability precludes its introduction at the trial.
I understand. And as far as the motion's concerned, I'll grant that under those conditions.
Thank you, Your Honor.
All right. Let's move on to the next one.
Your Honor, this should be relatively quick. This is motion to limit number 37 to create Mr. Goldsmith testimony. Chris, can I have that up, specifically page 4, please?
Whose testimony is this?
This is Dr. Goldsmith. He was hired by Neale Water to be their epidemiologist. And page 4, Chris, I'm sorry. The reply. Okay, so this is from his March 24th report. He did a causation assessment. What emerged was a very serious outbreak of rare and acute typo in there. Liver disease affecting children early and adults later. There's one fatality, that's Ryerson. The FDA is not going to a clear causation process or exposure to hepatotoxic chemicals. One exception was the finding of hydrazine detected 3 times in the real water concentrate. Based on the evidence I've examined, the cases of ALF, which means acute liver failure, cannot be explained by other clinical risk factors such as excess alcohol or drug use or exposure to patients with infections, hepatitis. Quote, in my opinion, it is more likely that hydrazine contamination in the real water concentration explains the ALF outbreak. Next point, Chris. Next page, just his question and answer. We opposed him, and basically I took this deposition like a trial preservation deposition. So summing up your opinion, hydrazine is the cause of the outbreak. Hydrazine does appear to be the source of the outbreak, the acute liver failure outbreak. Are you applying to this to a reasonable degree of epidemiological certainty? Yes, that's correct. Next one, Chris, same page. He says his opinion applies to the group of plaintiffs in this case. And then in the last opinion, he talks about the orphans testing. He says that's the smoking gun that we, concerned with the epidemiology and field investigation. This matches up with what the FDA chemists found in concentrate. And so he says it's a company-wide concern. It's not just limited to 5 gallons. So that's the fundamental opinion of Dr. Goldsmith. And so we filed a motion to pre-admit it because I have a sneaky suspicion that Mr. Odou is not going to bring this guy to trial. So what does pre-admit mean? Your Honor, I think there was some concern in the opposition that I wanted to play this for the jury. And I thought about that, and I just don't think that really works good. I think I'd rather put his picture up and have some bullet points about what he's going to say. The flow just wasn't good. I'm trying to play it because it's just too long. So the reason we want it pre-admitted is we want to discuss it with the jury at the outset of the case, and we don't want to have a concern that he won't be allowed to testify when we do the case in chief. So pre-admit, not to the extent I want to show his deposition to the jury, but pre-admit to the extent that we know it's going to be evidence that comes into the case. And that in their opposition appears to be a timing concern, which is we should wait until the trial starts to make this determination. That doesn't help me in the opening statement. You know, I need to know that it's coming in or not coming in. So that's the motion in a nutshell, Your Honor.
All right, Mr. Odou, sir.
Thank you, Your Honor. Joel, doing that for real water. I'll be very brief as well. Mr. Kemp hit the concern right on the head, the nail right on the head. They want to take Dr. Goldsmith's testimony and pre-admit sections of it out of context. I think when we talked about this, feels like 2 weeks ago, but could have been longer. The court talked about general causation and specific causation. We pointed out that Dr. Goldsmith does not have specific causation opinions. In fact, Dr. Goldsmith has never reviewed the medical records of any of the plaintiffs in this matter, whether it's Kathleen Ryerson, Mr. Bottice, Mr. Haley, who you settled with, or any of the other plaintiffs for that matter. And therefore, he has no medical opinions. The court's gone to great pains to look and review testimony from a number of medical providers that they must meet the hallmark standard, that they must testify to a reasonable degree of medical probability. And Dr. Goldsmith is no different. And he did not testify to a reasonable degree of medical probability as to specific causation for any plaintiff in this case. And for that reason, his testimony being taken out of context is highly prejudicial. If plaintiff wants to subpoena Dr. Goldsmith to ensure that he comes, or they want to try and then later admit his deposition because they are unable to subpoena him, that's an argument for a different day. But this testimony should not be pre-admitted. We've seen all throughout the oral arguments of the motions on this case how plaintiffs have tried to put words in Real Water's mouth as to what we're arguing, and they've been wrong each and every time, and they're wrong this time as well. And we think that's not fair. Plaintiffs get to go first, that's the burden of proof, but they don't get to take our expert out of context and start prejudicing the jury during opening statement. That's improper, it's argument, and it does not belong. And obviously, if we needed to make an objection during opening, we will, but it's very disruptive, and so they're asking to pre-admit it to use the privilege of...
Is he local?
No, Your Honor, he lives in Oregon, Your Honor.
He is not, Your Honor, and certainly they can make a showing that if they want to, that he's unavailable and admit the testimony at the appropriate time, if that's what they intend to do. But to use it in an opening statement is just unfair. And again, I think I've said this many times, Real Water is not going to take a position inconsistent with Dr. Goldsmith at any time during this trial. Thank you, Your Honor.
Okay, I just have one question on that, because I was listening closely. What if he doesn't, it doesn't appear that Mr. Kemp's going to use the deposition in opening. He's going to use bullets. I assume it'll be a PowerPoint of some sort.
I would assume so too, and certainly if he's going to, take a chance that this court is going to admit the deposition testimony in lieu of live testimony because Dr. Goldsmith is unavailable, I don't think it's much of a chance, but I think, it's still a risk that he takes, that's fine. But, again, I think it's a fine line between argument and stating facts. Dr. Goldsmith's opinions are facts as to general causation. Real Water is not going to take a position contrary to those opinions. And so pre-admitting the testimony also is kind of pointless at this point because there is no dispute as to what he said.
I understand.
Thank you, Your Honor.
And Your Honor, from a bystander's perspective or a third party's perspective, when this deposition was taken, there was no proffer of Dr. Goldsmith as an expert to offer opinions on X. Had there been, we could have tailored that, made necessary objections, etc. As you've seen, I think Dr. Goldsmith gave some general epidemiological opinions for which he's eminently well qualified, and then appears to have given, or perhaps did give in the deposition context, specific causation opinions for which there's no foundation or qualification. And that's exactly what we would have objected to at trial. I think that's one reason that it shouldn't be pre-admitted and that there should be a distinction between, as Mr. Odou has repeatedly argued, between his general causation opinions and the specific ones.
I guess what we're really asking for is an indication that the deposition, at least the parts they can see, is going to be pre-admitted. There's some hot button issues in there, like the case specific stuff. In the citation we showed you, he said it was case specific. When Mr. Hoffman had him on cross, Mr. Hoffman did a good job showing that he didn't look at any medical records and kind of impeaching his opinion. And so what I intend to do is kind of stay away from that during the opening, because why? It's going to be tough enough to explain the case to the jury without getting into that kind of granularity. But so all we're asking for is a ruling that this deposition, that we can use it in our case in chief. After that, I'm taking my own chances what I put in front of the jury. And if I put something in that doesn't ultimately come in, I'm not asking the court to rule on the page and line designations at this point. But if I put something up that doesn't come in, I'm sure they're going to jump on it and remind the jury that it didn't come in during the closed argument. But that's the same thing I can do with any expert. If I say with any expert and put up his picture and the bullet points, and one of those bullet points doesn't come in, I'm running a risk. Okay, I'm not running any more of a risk with Dr. Goldsmith than any others, except I want to make sure that the court rules that it's going to come in, that we're not going to go through this charade that I got to subpoena him up in Oregon, and I can't even talk to the guy. How am I going to offer him an airplane ticket? I'm pretty sure. Mr. Odou hasn't said it directly, but I'm pretty sure they're not going to bring Dr. Goldsmith to trial. I just want to know that the plaintiffs are allowed to use whatever is we think can be admitted without any controversy in our case in chief during the opening. That's all I want to do.
Well, I understand that. Here's my question, because understand this, Dr. Goldsmith is not a party to the case. And for example, if there was a managing speaking agent on behalf of one of the defendants, maybe you could put his deposition up and deal with it appropriately. But as far as Dr. Goldsmith's concerned, he's a expert, and which is a different category of witness, and we all understand that. It seems to me that the appropriate way to do it would be, yeah, you can put up the bullet points and list what you anticipate he's going to testify. And then there's an issue regarding availability. Hypothetically, if he didn't show up after being subpoenaed, you could use his whole deposition. If he shows up, you put him on the stand. That's the appropriate way, it seems to me, it would be to handle that.
Well, technically, Judge, I don't even think I have to subpoena the guy because he lives out of state. I
I
don't have to try to serve an out-of-state subpoena.
Yeah, he's not under the jurisdiction. That's true.
And Oregon is well over 100 miles away. So,
What about that, Mr. Odou? Slightly different.
Yes, Your Honor. That is the issue, that he is out of state, and whether or not we choose to call him really depends on the plaintiff's case in chief. As I stated, Real Water is not going to take any inconsistent position with what he said. So whether or not we even need him to testify becomes an issue.
I just want to take a quick look. Rule 34, right? That uses of depositions.
Yes,
Thirty-
32.
A4, Your Honor.
It says 100 miles, Sean.
No, you're right. It says 100 miles.
I think it actually 2 miles of a different state because the court doesn't have subpoena authority in other states.
A4. Unavailable witness, a party may use for any purpose the deposition of a witness, whether or not a party, if the court finds, will ignore A. I don't want to give bad karma to the witness, right? What appears to me when I look at the subparts, they're not conjunctive, they're disjunctive, right? It is what it is.
I think there's no question that he'd be unavailable in that circumstance, Your Honor. But that doesn't render everything he says in the deposition admissible.
No, I agree with that.
And he's, without a proffer and without a qualification and without the ability to voir dire the witness, in light of that proffer, I think that tendering somebody for opinion testimony is particularly problematic. I think 99 times out of 100, when Mr. Kemp has used this rule, or I've used this rule, it's been with a fact witness. And it's a lot easier in that scenario because you're just ruling on standard evidentiary objections.
I can say whatever I want to about it, but I expect their testimony to be just as long as it's in good faith.
This is, and I'm not saying you're wrong in that regard because, for example, and I think what you're saying, look, Judge, there can't be carte blanche use of the deposition.
Yes, sir.
That's because there might be objections, there might be issues regarding foundation and all those things. I understand that, I do. And this is what I'll do. I mean, the rule says what it says. I will grant the motion with a caveat. There's been no waiver of lack of foundation. There's been no waiver of objections. There's been no waiver of any of those things. And so, and this is how we'll handle that. It's like we handle the uses of depositions. Before the deposition is read, assuming he doesn't get called, there'll have to be the appropriate designation of portions of the transcript, number one. You know how that's done.
Right, we've done that, Your Honor. We've submitted the page lines already.
Okay.
And we've objected and countered. I think this is a central enough issue that it might be worth resolving the admissibility of those prior to opening so that there's not uncertainty or damage done.
Well, I think the hot button, like I said, is the case-specific stuff, so I think I'll try to stay away from that. So.
Yeah, it won't surprise the court to hear that Mr. Kemp and I have slightly different takes on it. I think there may be a few more hot buttons than he does. Yeah. But certainly the specific causation stuff is out. I think a lot of the...
Out for the opening, not out.
Well, I think it's out as to Goldsmith, but in any event, Your Honor, that only illustrates the issue, and I think that the more confidence the court can provide all the parties prior to it being aired to the jury, the better.
Yeah, Judge, I don't mind. I mean, I think our designations and counters, I can't remember if we've done objections yet, but what I was talking to Mr. Pepperman about the other day is we've done designations on 26 or 28 witnesses, I can't remember which, and I know that probably about 12 or 14 of them are probably live. So there's probably 5 maybe important depositions that would be first 2 weeks of trial. And so what I suggested to Mr. Pepperman is that we try to focus on those 5, get those to the court when we go through this process and get a ruling on those. And I don't think Dr. Goldsmith was initially on that list, but I'm happy to add him to that list.
Put them on top.
How about this, Mr. Odou, sir?
Just standing up, Your Honor, I agree. I think there's these housekeeping issues that we should resolve.
Yeah. I mean, I haven't looked at the designations. And Is there a date sometime? We're in Fort Dyer. Do we have all 5 days next week? Isn't there some sort of?
We only have 4 days because of the holiday run.
Monday's open, Judge.
Yeah. We're not working
For now.
Monday.
Hard pass.
For now, we're not working Monday. We're not working. We're not. You know what we need to do? I don't even know if this is even possible. Maybe after this is what we'll do. After we select a jury, we'll start opening statements, I guess, the next afternoon. And well, how long are we going to take for openings? Do we know?
I'm running at 2 to 2:30 right now.
You mean 2.5 hours? So we're talking about 2 or 3 days for openings, probably. 2 days.
A full day, it would stretch into a half. I'm around 90 minutes.
30 minutes.
Right. Well, anyway, maybe this is what I'm thinking about doing as far as this specific issue before openings, but we have to do it before then. How long is jury selection going to take? 2 weeks?
I think we're going to go the full 4 days, Your Honor. At least.
I'd say at least.
At least.
I don't have the faith that you guys do. I really don't. I'm thinking minimum 6-7 days.
Okay.
What do you think, sir?
I said at least. I said he said 4 days. I'm saying at least 4 days. We've probably got more.
We have more. All I'm trying to do is pick out a time where because we don't have time this week to go through the depositions or
No,
anything.
Your Honor, and I don't think the process isn't quite done.
Yeah.
And that's why I suggested we just do the hot button ones, the ones I think are going to be involved in the first 2 weeks of trial.
Yeah, see, but I don't know what those are.
I do, because
I know.
I'm calling the witnesses for the first 2 weeks of trial.
Yeah, but I mean, as far as the deposition designation, the objections, and all those things, I don't know what they are.
Judge, I can weigh in on this one. So I'm sure it's going to shock you to hear that this is shaping up to be a monster time suck. I mean,
It is.
It
doesn't surprise me, though.
We served our designations. We received the responses, objections, and counter designations. And I've been going through them, and my associate, Brianna Switzler, has been working day and night on them. They've objected to virtually every single question in every single one of these. It is just beyond what's reasonable here. And so I think we need to get some guidance from the court to be able to say, look, we're not listening to leading objections, which to open-ended questions where there was never an objection made at the deposition. I mean, it's just because they don't like something doesn't mean it's irrelevant. A lot of them are just background questions and setup questions. It's just every single question there's objections to, and it's just taking a long time to even prepare the responses. So it's a problem. I don't know what else to say besides that.
Okay.
And Judge, I advise the court, we're trying to build live witnesses in for the first 3 days of testimony, just to give the parties in the court more time to play with this issue.
Well, I understand that, but I think the big issue is what will be placed as one of the bullet points at the time of opening statement, or many bullet points. I don't know.
Your Honor, I can give my slide to Mr. Neale if that solves that problem. I'll give him my Goldsmith slide.
I'll take it.
Well, I know you'll take it, but if it solves the problem, okay?
Okay, how about this? What's today? Today's Tuesday.
Tuesday's off.
Tuesday's off. Okay. How about this? Can you give him the slide, and he can review it by tomorrow morning? I guess.
How about tomorrow I'll bring it to court. How's that?
How's that, Mr. Odou?
Yeah, I can look at it, Mr. Neale will
Absolutely.
be here.
I
Okay.
didn't say I'd give it to you.
Oh my God.
You're baiting me on that one, hook, line, and sinker,
Yeah,
you
there
got
you
me.
Yeah, let's see what the slide says first.
Okay.
Okay, because I can't rule based upon what I don't know. Okay. All right, so there goes another 20 minutes.
That was a quick one.
Right, so where do we go now for the next half hour? Oh, I'm sorry, Michelle, I'm sorry. Good afternoon. And Michelle she's one of our supervisors as far as clerk's office is concerned, and I know there's issues regarding electronic exhibits versus hard copies, and apparently this is one of those cases where we're going to have a lot of hard copies. And they want to be able to, it's my recollection, have the jury potentially get hard copies for the purposes of deliberation, but what do we do as far as trials concerned?
If we're going to use the electronic exhibits, Judge, those are the exhibits that would be marked with the admitted stickers. So what would happen, what would be a concern with giving another set to the jury is that they would not be marked. And I'm assuming there's 10,000 pages or 10,000 exhibits. Exhibits, so that would be a lot to have to remark. That's the purpose of the electronic exhibits, so that we can mark them electronically. So the jury would get the what's called our golden drive. Not the golden, they would get our working drive, and they would use a laptop that you guys would submit, and it would be a clean laptop, a laptop with nothing else on it. And that's how they would view the exhibits, through that laptop. And we would provide them with the marked exhibits from our working drive. So another set of hard copies would kind of be duplicating what we've already done.
So Michelle, is that saying then that what you need us to do is determine, we have a meeting tomorrow at 11 o'clock, we have to decide there, if we're going to, we want the jury to have hard copies that they deliberate with, then we have to have hard copies of everything. Is that what you're telling us?
Yes, you need to go either electronic or traditional.
Okay, so that doesn't mean I'm sorry. That doesn't mean that if I'm showing something up on the monitor that isn't still a hard copy, right?
Yes, you can use your set of exhibits electronically, but the clerk's version and what goes to the jury, if you're going to switch to the traditional exhibit or hard copies, we would need that. We would need all those binders.
Is there a preference, Michelle, that you have with regard to how you'd like us to provide those to the court? Yeah, in other words, hard copy or electronic, which do you prefer? Does the court have an opinion at all? And you don't have to tell us opinion. You can say, I'd like to pass on that question. That's fine too. We're just asking questions so that when we have our meeting tomorrow, we have something to go with.
We are okay either way. It's really up to the judge. It's the department, it's case by case.
All right, because part of the evaluation we're making is what do we want the jury to be able to view? In other words, what's better for the jury in order to make a decision? Is it an electronic copy on one monitor, and I've got so many people back there and one monitor? Or do we have to have hard copies? And we can make copies of copies, right? But what you're telling me is that I can't have a monitor back there and 8 copies with that. That's never going to work. So we've got to figure this out. That's right, correct?
Yes.
Okay, thank you.
Yes, and we've done that before. The electronic exhibit protocol was created for the larger trials, Queens Ridge, City Center.
Yep.
Those are the cases that protocol was developed for.
Okay.
So they've done it, and we've done it successfully. I'm not sure. I don't recall there being more than one laptop, but it's up to you. It's up to Judge.
Michelle, I have a question. I was in City Center and Queens Ridge, and I can't remember what I had for lunch yesterday. Can you circulate whatever those guidelines were from one of those two so that we all have it and we're on the same page?
The guidelines that Tori would have sent out,
Included?
they included the protocol. That is the protocol that that was created for those large trials.
Thank you.
But we can certainly have, Tori can send it out again.
Yeah, if you don't mind, I mean,
Yes.
did that differ at all from the Queens Ridge model or
No,
the
that's the
older
model.
city center?
No, I'm sorry, that's the model that we've been using since.
This is what I think you might have to do, and I'm not sure what the appropriate way to handle it, but it might be electronic copies. You can have more than one laptop, can't you? If they agree, or is it limited to one?
So we could, if we wanted to have 9 laptops, we can do that.
Yes, as long as you guys stipulate that they're all clean, meaning there's no pictures, nothing, they're
Well,
just.
and how do we best take that with the court? Do we, I mean, we would go down, let's say, to Best Buy and buy 9 things, but they always, look, they come preloaded with all sorts of crap. You know what I'm saying?
Meaning they didn't have any pictures or any.
Oh, I hit the start button on a new laptop and it comes up with, you need this, and I need to do this firewall, and I gotta get all this other crap.
So litigation services is offered to provide a clean laptop for the jury to view.
So we can rent or something,
exhibits.
get 9 of them?
Yeah,
All right, that's easy.
whatever we need. If you need more than one, they can do it, but.
Okay. So we can do that.
You might want to, I'm not saying you need 8 for the jury, but maybe you might want to have 4, or you might want to have 2. You might have more than one.
You're gonna have your 4 alternates, so, right? I mean,
No, but
you
these
need-
back in deliberation are already gone.
Yeah, not every juror needs a laptop.
Yeah, but you might want to have more than one.
Yeah.
From a convenience perspective. I'm thinking ultimately you decide how many you want to have, but I think at least a minimum 2, because there's so many documents.
2.
But just as important too, there's going to have to be,
One for each set of table.
and this is what I think is going to be very important, there's going to have to be some sort of maybe hard copy of the exhibit list so they can use when they look at the, is that correct? Yes, so they can find them as they deliberate.
So an exhibit list is okay in hard copy, because it's actually the exhibits.
It has to be hard copy, yeah. You'll be providing, I think, 3 copies of the exhibit list.
Of an admitted
Yes.
exhibit list. Thank you.
Yes, we can, that one we can, maybe work with you guys to whittle it down to only the admitted exhibits.
Thank you.
Once they get there, right before the jury goes to the
Okay, that helps.
And I don't think, you're right, I don't think every panel member needs a laptop, but maybe 2, yeah, and something like that seems more appropriate than, I think 1 is not enough. I think 2, maybe 3, I'm not sure, but 2 minimum. That's what I think during deliberations, because they can be looking at different documents together as a panel, right? And is e-litigation services?
Yeah, Marks with litigation services.
Normally, what do you do? How many laptops? Depends.
But yeah, we can provide 2, no internet access, completely clean.
Okay. So maybe that's how we handle it. Mr. Pepperman.
No, I think whatever we need to do, that's easiest for the court. I just don't see how with all the exhibits, how that we do hard copies. I don't know.
Okay, well, we go with, if that's the concern, I know we have some here, but not all have been delivered. If that's the concern and you feel that electronic is the best way to go.
Are they all pre-marked, whether electronically or hard copy?
They've already been, from my understanding, they've already been validated with our, so that means they're pre-marked as proposed. So what happens is when you start to offer them for admission, we will electronically impose the stamp on there that says that they're admitted. And then once they're admitted, they move to a folder, an admitted folder that we would save on a thumb drive and give to the jury.
A hard copy list of the exhibits that have been admitted. Got it.
Yes.
One thing I'm not sure I understand is why we need, if we were to do hard copies, what's the purpose of having all the hard copies before they're admitted?
Sure, I understand.
So,
What's the purpose of who having the hard copies? The clerk
yes.
before they're admitted? That's where we would mark we would place the stickers on the hard copies to show, if you choose to use traditional hard copies, that's what we would mark as with any traditional trial. That's what we would mark as the admitted exhibits on.
But are they marked when they're admitted?
Yes, once they're admitted, she's going to sticker it, which shows that it has been admitted. Then once those traditional exhibits go to the jury, we would only give them the marked admitted exhibits. So if you have 10,000 and you only use 500, only 500 go back.
Do they retain the numbers that the parties assign?
Mhm.
They don't take on new numbers?
No, as long as you use the traditional hard copies. Electronics are different. They're different. They're numbered differently.
Well, I think one of the things that we were dealing with was, there are a lot of exhibits, but I think only a small number of them are actually going to be used. And so, well, at least I may have been confused. My understanding initially was we could submit them all electronically, so we have them all available, but only submit those ones that we knew we were going to either admit or were likely to admit in paper copy. And if one was admitted that wasn't initially submitted via paper copy, that we printed out and added to the binder of hard copies. And so anything admitted would be the paper copies only. That's just something I thought that maybe we could do to kind of narrow down the amount of printed exhibits that we have here, so we don't have all of them that we're really unlikely ever to admit or even use.
We will do whatever Judge tells us to do, but our concern with that is that we want, especially with such a high volume or large number of exhibits, the possibility of possibly mixing those up, the clerk would have to keep track of 2 sets of exhibits basically. And we want to, with such a large trial, we want to take out the risk of mismarking anything, making sure they're all correct. That's why we'd rather use one or the other. Now, when you use electronic exhibits, let's just say you have 5,000 that you submitted electronically, and then you find that you might, during the course of trial, want to submit 3 or 4 more hard copy exhibits, or you may find, I don't know, however many, 20 or more. We can mark those in addition to the electronic exhibits. So you'll have the hard drive plus 20 paper exhibits, but because if you submit more, you have to redo the validation process. So there have been cases where you've used electronic exhibits, but then you may add 2 or 3 binders of hard copies for the jury. But we don't want to do both hard copy and electronic.
Understood. If we use paper exhibits and only provided copies of a portion of those exhibits, not the complete set that's on the exhibit list, would that be possible or create any issues?
When for any trial that you're using, we have to have all of them.
They have to have all of them before the trial starts, and they're numbered, and they're proposed exhibits, and then once they get admitted with that number. Not all of them get admitted. Is that correct, ma'am?
That's correct, Judge.
Okay, understood. So it has to be all one way or the other, preferably not both ways because of concern over confusion.
Yes.
Understood.
In the cause of the error, the chance of error.
Very informative. I would ask if we could still have the leeway to meet tomorrow and discuss it, and then
As long as we have a decision tomorrow, it's fine. That's fine. Is that Michelle?
Yes, Judge.
Yeah, as long as we have a decision tomorrow.
Hard copy exhibits are due tomorrow.
I think that we're going to have to do electronic. If we were to somehow decide to do paper copies, and would it be okay if we copied them starting immediately and got them to you by Thursday?
I would need them as soon as possible because I have to go through them and we are off on Monday.
Understood.
Does that answer all questions on the exhibits?
Until we leave.
I agree. Quarter till, where do we go now? Do we have any stipulations? Do we have a stip?
Well, there was one motion, I thought 40 was included in 20, in the, so that should be granted, right?
What's 40?
Yeah.
So you just did the title?
So I'm assuming that should be granted.
That's consumed in my prior decisions.
Okay, and then Judge, believe it or not, we're kind of running out here. But the next one.
You mean
I
running
think-
out of no more motions? I don't believe that.
No, we do have some, but the list is getting a lot less. The next one on the list in order is the one about history, and I think that's gonna take probably about an hour. I don't advise we start that one. And the one after that jumps into the real water Tennessee issues, which I don't think was a good way to stand today, starting jumping into those.
I
So,
think Mr. Cavanaugh will appreciate that.
yeah,
I
so.
think we should put 41 off and do Jim's summary judgment first and then take up the Tennessee.
I have, whatever the people agree to on Tennessee, you want to start 41 tomorrow? Where is 41?
Why don't you just work through yours and then we'll get to mine after that.
Ours,
41.
and there's really, Your Honor, I think there's only
He's got 44.
3 of us left after this will be, what? His, Jim's,
Then,
Milwaukee's, and mine.
let me ask Jim a question, Mr. Neale a question. 42, plaintiff's motion limiting 42, 43, and 44. You really have an opposition to those?
43 on marijuana, there was some minor one.
I'm sorry, I would ask Mrs. Amos.
42.
42 now.
42 we do not.
Okay,
Say granted there. Okay.
So 42, there's no
Granted.
opposition.
Okay. How about 43?
Number 43 dealing with marijuana for Haley.
Different plaintiffs.
Different
Same
plaintiffs. First one
substance.
was Bottice.
That won't take long. We just need we'll talk afterwards. So
All right.
we're not going to argue against it.
And Batista's felony conviction? Or-
Felony conviction.
You're not going to oppose 44?
We haven't.
Did anyone oppose 44?
I don't think so.
Okay.
Mr. Odou, did you oppose 44?
Okay, so-
If I did, I'd withdraw right now.
Okay, so that can be granted.
All right.
I don't think I did, though.
No.
So, nobody
Did Ron
did.
Robbins oppose?
44, which one is that for the record? So,
44 is Mr. Batista's felony conviction.
and for the record, there's no opposition?
No opposition, Your Honor.
Okay, you can grant that.
Okay. Yeah, we're down, other than Real Water Tennessee, I think we're down to the last page here, which are
You're
all
on 38?
38.
38 to 1 going to
History one. Well, I think it'll take a while. 37, or 35 and 36 I have on the briefs. Do you care about 35 and 36? Maybe we can just knock them out now. 35 is Mrs. Ryerson's AFib and type 2 diabetes.
Any position on that one, guys?
I'm sorry, which one do you want?
35.
Plaintiff motion limiting number 35 to preclude reference to unrelated medical conditions. This is Mrs. Ryerson on
I think you
AFib.
submitted that, didn't you?
We said submitted, but I'm trying to see if we can get off the judge.
Yeah, I would like
that submitted. Okay, second one on another felony conviction of Brian Gallagher. That can be granted.
Anybody else?
I don't
Okay.
So you can
Which
grant
one, which,
36.
That's
Is this-
36, Your Honor.
Plaintiff's
Yeah,
motion
he's
limiting
already submitted.
Your Honor, do you want to go through what's under advisement for your benefit?
you can, Tori, want to check? I think I think we're probably pretty good in that regard because the law clerks have been working on it.
Maybe first thing tomorrow,
Yeah, I'll bring one in.
Okay,
And,
great. So you want to start with what tomorrow? The motion for the judgment on Tennessee?
No, we got your 38.
Okay. Okay, so you want to do 38.
And then I think it makes sense to do Jim's motion for summary judgment,
After 38.
and then,
And then where are we gonna go?
and then the four,
41.
if Jim does not
Okay, then we're gonna go through
prevail, then
41.
we do the four.
It's here tomorrow, that will help us.
Okay,
And also, instead of saying like your motion for summary judgment, I have no specifics.
So it's Real Water Tennessee's motion for summary judgment regarding UNFW's third-party complaint.
Motion number 393.
Thank you.
And that follows, the first hearing is going to be plaintiff's MIL 38.
That it?
That is it, Your Honor. Thank you so much.
thank you, Your Honor.
Thank everyone.
Thank you, Your Honor.
That